please identify themselves, please?
Yep. My name is Scott Lambert. To my left is Kevin Hanks, and to Mr. Hanks' left is Stephen Smith.
Great. And for ISIF Madfish?
Good morning. My name is Adam Brewer.
Good morning. Welcome, everyone, to the Office of Tax Appeals. So just as a standard caveat, the Office of Tax Appeals is an independent agency. Our role is to contain, and on the table in front of you should be an exhibit index listing all the exhibits that have been submitted by the parties to date. This includes exhibits A through H for CDTFA, and the taxpayers' witness declarations, which have been identified as exhibits 1 and 2. Did everyone receive all of the exhibits listed on this index?
Yes.
Yes.
And does CDTFA have any additional exhibits to add, or are there any exhibits that they believe are missing from this index?
We believe they're all present. We have no additional exhibits.
Great. Do you have any objections to any of these exhibits?
And we have no objections.
Okay. And in my February 19th, 2019 ruling, I also indicated that you would have CDTFA would have up to 30 days to submit written questions and/or requests of the two witnesses. Does CDTFA know at this time if they would like to exercise that right, or if they would like to waive that right?
So I believe we don't have any questions.
Okay, great. So when we go on the record, I'll note that that right has been waived. So does ISIF Madfish have any additional exhibits to add, or are any exhibits missing from this list?
No additional exhibits, Your Honor, and no objections to the exhibits entered.
Okay, great. So I also, at the pre-hearing conference, I mentioned that if you would like to bring additional exhibits to be distributed, so did you have copies of the witness declarations, or have they been distributed to CDTFA? Or
I have copies.
You have a copy? Okay, so we're good to go then. When we go on the record, I'm just going to omit all the exhibits listed on the index without objection. One last note is at the pre-hearing conference, I also informed the parties that we might consider whether the 40% penalty is an evasion penalty for purposes of tolling the statute of limitations and the applicable standard of proof. And I also mentioned that either party would have an opportunity to request additional time to submit briefing on this matter. Would either party like the record to be held open in order to submit briefing on the issue of the 40% penalty?
I was prepared to address that issue orally here at this hearing. Can we make how the hearing goes and decide after the hearing whether further briefing?
Okay, so I'll follow up with both parties before I close the record to determine whether or not there'll be additional briefing on that matter then. So I believe we're ready to go on the record. Are there any questions before we start?
No, Your Honor.
No.
Great. So we are opening the record in the appeal of ISIF Madfish, Inc. before the Office of Tax Appeals, OTA case number 18073396. Today's date is Wednesday, February 27th, 2019. The time is approximately 9:05 a.m. This hearing is being convened in Sacramento, California. For the record, would the parties at the tables please state their name and who they represent, starting with the taxpayer?
Good morning, Adam Brewer, attorney for the taxpayer, ISIF Madfish, Inc.
Thank you.
Scott Lambert. To my left is Kevin Hank, and to Mr. Hank's left is Stephen Smith, representing the California Department of Tax and Fee Administration.
Okay. Today's hearing is being heard by a panel of 3 administrative law judges. My name is Andrew Kui. I will be the lead judge. Judge Neil Robinson to my right and Judge Jeff Angija to my left are also members of this panel. All 3 judges will meet after the hearing and produce a written decision as equal participants. Although the lead judge will conduct the hearing, any judge on this panel may ask questions or otherwise participate to ensure that we have all the information needed to decide this appeal. The exhibit index in front of you identifies exhibits 1 and 2 for ISIF Madfish, A through H for CDTFA, and the joint exhibit, which is the decision from CDTFA. These are all the exhibits that the parties have submitted to today. Does CDTFA have any objection to any of the exhibits identified?
No, Your Honor.
And does ISIF Madfish have any objections?
No, Your Honor.
Okay, so I'm admitting all the exhibits submitted by the parties. That includes the exhibits listed in the exhibit index, which I just went over. These documents are admitted and entered into the evidentiary record without objection. The issue in this appeal that we are deciding today is whether the 25% penalty for fraud and the 40% penalty for tax collected and not timely remitted were properly imposed. In deciding this appeal, I notified the parties at the pre-hearing conference that OTA may address whether the 40% penalty is an evasion penalty for purposes of tolling the statute of limitations and the standard of proof. I offered both parties an opportunity to submit additional briefing on this matter, and we'll follow up at the end of the hearing to determine whether additional briefing is requested. Also, the appellant submitted 2 additional declarations on February 25th, 2019, and CDTFA has waived the right to submit written questions and or requests of the declarant in this with respect to the declarations. So we're ready to start, and just so everyone has an idea how we're going to proceed, we'll start with the taxpayer. The taxpayer will have approximately 20 minutes, followed by the CDTFA, who will have approximately 15 minutes to do their opening presentations. Then we'll have questions from the panel, and followed by 5 minutes for each side for rebuttal. So we're ready to proceed, Mr. Brewer.
Thank you. Good morning. The imposition of fraud penalties should not be made lightly, and for that reason, we are here to address that issue alone. The assessment of fraud penalties carries heavy implications, including an expanded time frame for assessments through examination, significant financial burden in the form of additional penalties. They limit the taxpayer's ability to move past a failed business and carry a social stigma. The courts have recognized this implication when they included a safeguard requiring civil tax fraud be established by clear and convincing evidence in Board of Equalization versus Renovisor. The U.S. Supreme Court held in Colorado v. New Mexico, clear and convincing evidence means evidence is highly and substantially more likely to be true than untrue, and the fact finder must be convinced that the contention is highly probable. In the present case, CDTFA failed to meet that burden. Based on my reading of the audit report, it reads largely that the audit finding of fraud was based on voided transactions, taxpayers' inability to provide sufficient accounting records, taxpayers' experience operating said business, and the underreporting itself. With regards to the voided transactions, I suspect voided transactions are present in every restaurant in the state of California. They can have a legitimate business purpose for takeout orders that were never picked up by customers, orders that were returned or refunded based on unsatisfactory service, or for orders when the staff makes data entry. Their mere presence alone does not justify a finding of fraud. ISIF Madfish at its heart was a small business operated by individuals with insufficient experience, insufficient understanding of tax withholding and reporting, and insufficient record-keeping practices. I don't condone mistakenly reporting monthly sales as quarterly amounts, but I also recognize that this mistake is just as likely due to inexperience as it is due to fraud. The audit report supports a fraud finding based on taxpayers' experience operating a business. In the same report, the auditor finds that the business misreported taxable sales from the very year of inception of the business. This finding does not support a fraud determination and makes it at least as likely as not that the taxpayer never fully grasped the process of reporting taxable sales. A finding of fraud requires more. Attaining a seller's permit, then misreporting taxable sales doesn't require to the level of fraud. Operating a business for a number of years and mistakenly reporting taxable sales for much of that time doesn't rise to the level of fraud. A finding of fraud requires more. While not binding on state tax matters, The Internal Revenue Manual does provide insight into federal government standard for making a fraud determination in civil tax cases. The IRM provides that indications of fraud like misreported sales figures or voided transactions don't establish the act of fraud was done. They require more. A finding that a particular act was done for the purpose of deceit, subterfuge, camouflage, concealment, and some attempt to color or obscure events or make things other than they are. Finally, the taxpayer presents the declaration of June Kim and M.J. Lee. Ms. Kim and Mr. Lee are both currently in South Korea and were unavailable to appear personally or telephonically. Ms. Kim attested to the fact that she prepared the sales and use tax reports for the business. She states she was never instructed to fraudulently or intentionally misrepresent sales figures. Similarly, Mr. Lee states he never intended to fraudulently or intentionally misrepresent sales figures. The audit report states without factual support that the taxpayer fraudulently reported taxable sales. A proper finding is that the taxpayer underreported taxable sales without the requisite fraud or intent to evade. Thank you.
Okay, if CDTFA would like to make their opening presentation.
In this particular case, the business operates a restaurant that serves alcoholic beverages. The audit was conducted for an 8-year period, and during that 8 years, fraud was, or an intent to evade was established. At this time, the department would concede the first 2 years of the audit, which is through the third quarter of 2010. And the reason for that is that those periods were expired by statute. And we do understand that there is no statute of limitations for fraud. There is no 8-year statute of limitations. An 8-year statute of limitations would be for failure to file returns. Returns were filed for this period. So essentially, we can go back to the start of the business, in which we did in this particular case. Unfortunately, there were no records that were provided, and in my understanding of our policy, the department's policy, is that records need to be available in order for us to establish fraud or assert fraud in that case. And although I was able to locate the income tax returns for 2009, and there was an understatement for that period, I don't believe it rose to the level of an intent to evade during that particular period. So with that, the department will concede those first 2 years, and I would be available for questions if you do have questions about that. My presentation will be from the fourth quarter of 2010 through the end of the business. The fourth quarter starts with October 1st of 2010. What we discovered upon conducting the audit is that there was a difference between the sales on the income tax returns that were reported and the gross receipts that were reported on the income tax returns and the taxable sales that were reported on the sales and use tax returns. We also noticed that the markup for those periods were below what we would expect for that type of business, and so we did additional testing. The additional testing was for a 2-week period in 2014, and we established a credit card percentage, and we applied that credit card percentage throughout the audit period. So that's the basis for how we conducted the audit, and I understand that the measure of tax is not at issue here, but I thought it was important that we just set a foundation of how we established the liability. So for the 40% penalty, what we did is compared what was reported to the sales that were reported or recorded on the point of sale system. and the 40% penalty was applied just to those periods, and those periods were only those records, the POS data, was only available to us starting October 1st of 2011. So the 40% penalty only applies, or it's only been applied for the period of October of 2011 through June of 2013. I'd also like to point out that there was no waiver obtained during this audit. There was a waiver obtained, but there was no waiver. There was no open waiver at the time that the notice of determination was issued. So based on the notice of determination, the second quarter of 2013 is the first quarter that would be open to statute without the fraud penalty. The second quarter of 2013, a 40% penalty was applied during that period of time. So for Section 6597, which is the 40% penalty, sales tax reimbursement must be collected, and it was during that period of time, and it was shown on the point of sale reports. So there's two requirements once that's established. Is one, whether there's a 5%, at least a 5% of error in each particular quarter or return filed, and that there's at least a $1,000 difference average per month. The taxpayer was filing on a quarterly basis, and so essentially they'd have to have a $3,000 difference in order for the 40% penalty to apply. If you take a look at the combined or joint Exhibit 28, it will show each one of those qualifications. So if you look in column F, it's also titled, or the description of the schedule is Exhibit B. It's Exhibit 1 of page 6 of 6 of the notes of determination. And B, you'll see a percentage of error that's larger than 5% for each quarter, except the third quarter of 2013, and I'll point out that the 40% penalty was not applied for that particular period, that the 25% penalty was. And then also in column G, the average monthly difference was substantially above $1,000 for all periods except for the third quarter of 2013. So, the department believes that we've established clear and convincing evidence of the intent to underreport or to evade the tax. The evidence is their sales tax was collected, which is knowledge that the taxpayer was aware that they had a liability. The differences are unexplained. They're large and they're consistent in each period. If you turn to page 27 of the joint exhibit, one of the, what I would say, one of the reasons taxpayer gave for underreporting is they thought they were reporting just the last month of each quarter, so they were only reporting monthly. If you take a look at column B of page 27 of the joint exhibit and look at column B down to line 9, these are the amounts that the taxpayer was, or the appellant was reporting in each one of the quarters. And as you can see, it was in some ways going down for a while until the last quarter, or the second to last quarter, where they reported $264,000. The amounts that were established in the audit are in column E, and those figures are substantially different than what was reported in column B. So if you would think if you just reported 1 month, essentially if you multiplied the figures in column B by 3, you think you would come close to the amounts in column E, and you can see that they're nowhere close to each other. Also, evidence that's presented by the department for one of the returns, exhibit or page 70 of the department's exhibits, is a transcript of the third quarter 2011 return. And what you'll see is the amounts that are being reported on prepayments, which is the first prepayment would be the amount of $24.98. The second prepayment is $25.12, and then the total tax that was due for that quarter, or what they reported, was $57.30. What you can tell is that an amount is being reported for each particular month, essentially, and that there wouldn't have been just 1 month reported. Another thing that had come up was there was an inspection that was performed on the taxpayer on October 28th of 2010, and that's on page 65 of our exhibits. And essentially what happened here is that we went out to do an inspection. That's a normal procedure that the department does on a regular basis throughout the different areas, and they will visit businesses and take a look at the amount that the taxpayer is reporting. We'll take a look at the business, and we'll see if the two match up. What we discovered is that the reporting appeared to be underreported for that period of time, and the taxpayer indicated that they had reported, or they had made sales of about $2,000 a day, and that on the day before, actually, they had made sales of $2,500. So the department contacted the taxpayer afterwards and asked them to file amended returns for the first and second quarter of 2010. The taxpayer did that, and what you can then see from the reporting is that, and this is back to page 27 of the joint exhibits, if you take a look at the third quarter 2010, after we had went out there, you see where the taxable sales increase. It went from 91,000 to 111,000. The next quarter went to 109,000, and then it steadily dropped after that point. The department believes we put the taxpayer on notice at that time to properly report. They were aware that they were underreporting, and not only did they increase their reporting during or after the scope visit, but in fact, they accelerated their underreporting. Their sales, if you look at column E, in fact, increased, and their reporting decreased. So, based on that, that and the fact that the corporate officer had other businesses before this, was involved in.
I'm sorry, a quick clarification, because I'm following along on page 27, and I only see columns A, B, and C, but you referred to...
Well, I referred to the joint exhibit, 27, page 27.
I'm sorry. Oh, I'm sorry, I was looking at
maybe I didn't say joint. I should have, so I apologize for that.
Please proceed.
Yeah. So anyway, it's on... so I'll go back over that. It's page 27 of the joint. And so if you take a look at column B, you see the amounts for third quarter of 2010, which was right when the scope inspection took place. You see where the sales increased. The next quarter, it's also high, and then after that, it starts to drop off. If you look in comparison to column E, the actual sales were increasing during that period of time, when in fact the taxpayer was starting to decrease the amount of sales that they were reporting. We don't believe that there could be any misunderstanding as to the taxable sales that were taking place. During the time period from the fourth quarter of 2010 through the third quarter of 13, the taxpayer reported just over $1 million in taxable sales. During that time period, just their credit card receipts alone were $3.6 million. That's not counting the cash sales that were made to the business. So there was a substantial underreporting during that particular time period. I believe that concludes my opening statement.
Yes, I would just like to get some clarifications first on the concession. Are you conceding both the tax and the penalty, or just the penalty?
We're conceding the tax and the penalty because there is no statute open during that time period.
Right, and could you clarify the revised measure that's now at issue after accounting for your concession for the tax and the penalty? Have that?
Well, I don't have it. Well, I have. Well, I can get it. What I believe the measure should be is $2,877,667. So, and I believe what that is the figures in column D from the Joint Exhibit 27. And if you add up the figures in column D from the fourth quarter 10 through the fourth quarter of 2013, it should add up to that amount. And so the difference that we're conceding would be the difference between $4,038,768. I'm sorry, $4,038,768 is the amount that we originally have. So the difference between that and the $2.8 million would be what we concede.
So approximately $1.2 million is remaining
No.
at issue?
No, the 1.2 is what we're conceding.
Oh, I'm sorry. Okay.
Yeah. So it would be from line 9 through line 21 of column D, we believe is the $2.8 million.
Okay. And I had one clarification because I believe you had mentioned that the concession starting or going through the third quarter of 2010 was based on it being out of statute. And I'm looking at page 2 of the decision, footnote 1, and at that footnote it says, absent a finding of fraud, the NOD would not be timely issued for the period through March 31st of 2013.
Right.
So I guess I'm just wondering if you could briefly clarify
Sure.
that footnote in relation to your concession.
Sure. We're not conceding the fraud. What we're conceding is the period in time that we asserted fraud, that our policy is and has been, I'm going to say since I believe the early 90s, it could have been the 80s. We did have a different policy at one time that would allow us to do this, but the policy was changed during that time period to say that if you're going to assert fraud to a period that has been, that the statute has expired, that you have to have records that would establish fraud. And there's a section of the audit manual that I can refer you to that speaks specifically to that. And although you might be able to read the audit manual a little bit, it may be a little bit vague. It is clear that this is what our policy has been and is for quite a while.
Okay, so starting with third quarter 2010 is when you have records of tax that was, I'm sorry, fourth quarter of 2010 then is when you started having records of tax collected but not remitted. Is that
That's right. As long as we have some kind of evidence. So we could have, say, like an income tax return, or you could have merchant statements or bank statements, anything that would show that there was underreporting or an intent to evade for that period of time. Even if we developed some other method of establishing that liability, we'd be able to hold open that period of time. But absent records, and I believe there may be some exceptions to that where we would be able to go back and open up some periods, but based on the audit manual section, that has not been my experience in the time that I've been here, as far as anytime we've asserted fraud or an intent to evade, that there's always been evidence during those periods of time to establish the intent to evade.
okay? And just so I'm clear, with respect to different portions or different audit items, you're asserting both fraud and the 40% penalty for periods that are remaining at issue in this appeal?
No.
Yes.
We're conceding? No.
He said
We're conceding?
asserting
Oh, we're asserting. Oh, I'm sorry. I thought I heard
Asserting.
I thought I heard you say conceding.
Oh.
No, asserting. That's correct.
Okay. And I did have a question for the taxpayers' representative, because I understand from your presentation you were referring to this potentially a portion of the understatement being attributable to voided transactions, and I just wanted to clarify, because my understanding was that the taxpayer was conceding the amount of the audit liability, and to the extent that voided transactions were a part of the audit liability, I was just wondering if you could provide some clarification on that.
Yes. My reference to the voided transaction was only in light of the audit report supporting a finding of fraud based on the presence of the voided transactions. So I was just addressing them, not to state that we contest the underlying additional tax owed by the taxpayer, but simply that the presence of voided transactions itself was circumstantial evidence of the taxpayer's intent to underreport or intent to evade.
Okay. I guess just to clarify, since there was this new concession, I just wanted to make sure the taxpayer, they were still disputing the remaining fraud and 40% penalties.
Correct. As I understood it, the concession is just through 2010 third quarter, correct?
That's
So
my understanding.
if my understanding is correct, it's the bulk of what is owed by the taxpayer, and as a result, the bulk of the fraud in 40% assessments would still be proposed, correct?
I let the city TFA respond to the amount.
The 40% penalty would still be at play here for the entire period of time, because in order to have the 40% penalty, to apply that, you have to have the records to do that. So we had the records for all those periods where the 40% penalty was applied, but the 40% penalty only took place starting in October of 2011, because that was the first period that we had the point of sale returns. So that's the first period where the 40% shows up, but the 25% would apply to the rest of the period, with the clarification that there were some measures of tax where we applied a different penalty to that. There was one quarter where we applied a 10% negligence penalty, and then for the mandatory tips, there was no penalty applied at all. And I think the issue comes down is there was some misunderstanding of the application of the 6597 during this time period. That's not our policy. We should have applied a 25% penalty to all the measures of tax other than the measure that was applied with the 40% penalty. It was an error on the department's part because of misunderstanding. It's to the appellant's advantage, and at this point, we're not recommending an increase due to the penalties.
Okay, and with respect to, I guess, for the CDTFA, with respect to the periods that have a 40% penalty and the 25% penalty, I had indicated previously that we might address whether or not whether 40% is an evasion penalty. If it weren't an evasion penalty, potentially the applicable statute wouldn't be open for periods prior to, I believe, 2013, as noted in the decision and recommendation on footnote 2. Does the CDTFA have a position on whether or not those periods would be barred, or whether or not the finding of fraud for different items would hold open the statute?
Our position is that the periods would remain open because if the panel were to conclude that the 40% penalty isn't an evasion penalty, we would ask that but we believe that we've established by clear and convincing evidence an intent to evade tax, so we would ask the panel to apply the 25% fraud period, leaving those periods open if the panel were to conclude that the 40% penalty doesn't apply.
Okay, so CDTFA would be asserting in the alternative argument a 25% penalty in lieu of 40% if the 40% is not an evasion penalty.
Correct.
Okay.
Your Honor, if I could just get clarification on that point. Is CDTFA's position that the 40% penalty is applied as a matter of statute when the underreporting exceeds $3,000 per quarter or $1,000 per month, or is it a discretionary penalty that's applied similarly to the 25% penalty?
Well, I can't answer CDTFA's position, but if they would like to clarify
our
that.
position is that the 40% penalty is an evasion penalty, but it's different from a 25% fraud penalty in that there's these additional requirements about the sales tax reimbursement having to be collected and not reported under the statutory minimums.
Okay. So the 40% penalty is going to, the proposal is 40% is applied in addition to the 25%?
Not for the same periods. So for one, you can't have two evasion penalties in the same period. So each period we argue would either be 25% or 40%.
Just to clarify, there would be different amounts that the measure would be applied, or the penalty would be applied against. So if you had, say, underreporting of $1 million or $1 million in taxable sales for the quarter, and the difference between the book sales and what was reported was $600,000, the 40% would be applied against the $600,000, and the 25% would be applied against the remaining $400,000. So the two taxes are separate, distinct, or the penalties are two distinct penalties that are applied against separate measures of tax.
Even if those measures are for the same quarter reporting?
That's correct. Yeah.
Okay.
So in this, just to clarify, based on what you had read out of the DNR about the statute of limitations, that the 40% is applied, the only period that is open to statute that a 40% penalty was applied was the second quarter of 2013. The remaining quarters were open due to the application of the fraud penalty and the department's consideration that that the 40% penalty is in fact a fraud penalty.
For purposes of tolling the statute?
That's correct.
Okay, and I guess I'll turn to the taxpayer. I just wanted to make sure your understanding or concern was clarified and addressed.
I believe it was addressed. So as I understood it, the 25, the 40, the 10% penalties don't apply to the same principal tax, but they could apply to principal tax within the same quarter if those are if the type of tax collected is of a varying class. Is that?
I would just, one clarification is that we would not in the same quarter have a 10% negligent penalty and a 25% fraud penalty. I think in this case we do, but that's not what we should have done. The two are separate. The only time you can have a 10% penalty and a 25% penalty is when you have a failure to file, but which is a 10% penalty. You could have that in addition to the fraud penalties. That's not at play in this particular case, but generally our policy is that in any particular quarter you could have a 40% penalty on the difference between recorded and reported, and then the fraud penalty of 25% would be applied to the remaining measures of tax. And there is a mechanism, if we didn't think in other periods that there was fraud, we would have to have a separate notice of determination issued for those particular periods, and at that time then we could assert something other than a fraud penalty for those remaining periods. Say there was a substantial change in reporting or circumstances that would require us to do that.
Okay. I'm just curious, since this has to do with tax that was collected but not remitted to the state, does the taxpayer know what would have happened? Was this paid, for example, was this paid as salaries to the officers, or do you know what would have happened to this tax?
As far as I can tell, and I have somewhat limited access to records, just as the state did. Keep in mind, this was I think at the point I was retained, and this is going on several years, the business had closed. There's a bankruptcy involved, so records are somewhat limited, but based on what I've seen, I think it was just used for operations. I did see a tax return, a corporate tax return. I think the manager was compensated $57,500 as his wages for a full-time job, which I think is, I mean, to me in the Bay Area, that's not, enriched at the benefit of the state necessarily.
Okay, I should probably turn it over to the panel members to see.
Did you want to let him have his rebuttal? Okay, so I have two questions. One, not to beat a dead horse, but for the amount of the concession for that first 2-year period, I couldn't track it from the exhibit you were referring to, but I'm looking at page 8 of Exhibit A, which is the called jurisdiction tax and fee calculation summary. That lists by quarter the measure, the tax, and the penalty. So if I were to add up fourth quarter of 08 through third quarter of 10, is that an accurate spot for me to see the amount of the reduction in measure? I come up with 1.3 for measure reduction.
Yes, I
just want to make sure we're all on the same page when we get to the
yeah, we're right. So what you explained sounds accurate. I believe from page 27, it should equal removing the 2 years in column D, which is the understated taxable sales. Those two should be the same.
So just so we're on the same page and we don't issue a decision with an incorrect number, I don't want to be doing math. Is it possible that CDTFA could just submit a post-hearing submission just identifying the dollar amount of their concession?
That's a good idea, Judge Cui.
Yes, definitely.
Thank you. Should I set how much time would you need to do that?
How much are you willing to give us?
So I guess maybe at this point I should ask the parties if they know if they would like to submit additional briefing on the fraud versus 40% penalty issue.
We haven't talked about that yet at this hearing.
Because I could set the same deadline for both if that was going to be in play.
I don't know if this helps. I believe the taxpayer, well, as taxpayers' representative, we're going to request to submit additional briefing just because I feel even following today's discussion, it's somewhat murky waters as far as how that's assessed, and would like to address some issues with that regard.
Okay, so why don't I just submit a 30-day, so say Thursday, March 28th, and if CDTFA also wants to submit briefing, they could. If not, if they don't, they could just not submit briefing. And I'll set a Thursday, March 28th deadline for CDTFA to provide the additional clarifications on the concessions and for either party to provide additional briefing if they so desire. I'll turn it back to Mr. Anjija for his remaining questions.
So my other question, and perhaps it'll be addressed when the parties address the 40% penalty and whether that's fraud. If I heard CDTFA correctly, you were saying that if we were to decide that the 40% penalty was not fraud, then you wouldn't be asserting it. My question is, if it is not a fraud penalty, but the standard of clear and convincing is still met with respect to that penalty, wouldn't it still be imposed? In other words, you've exceeded, hypothetically speaking, if we decide that it's not fraud, you would have exceeded the preponderance standard that would otherwise apply.
Right. If you just consider it a regular penalty like negligence, we would apply it for those periods. But I guess it would only be the second quarter of 2013 that we would apply that to, though, because I believe the statute of limitation has expired for all the other periods.
If it's not fraud, it would be limited to periods that were still open under the 3-year statute.
Right. I believe that's only the second quarter of 2013 at this point, that the 40% was applied that was still open to statute.
Okay. Don't have any other questions.
Mr. Robinson, did you have any questions?
No questions.
Okay, so I believe we're ready to go to closing arguments. If 5 minutes per party, if the taxpayer would like to start.
Thank you, Your Honor. I'd just like to put on the record, with regards to the 40% penalty as interpreted as a fraud penalty, the taxpayer doesn't take that position. The taxpayer reads the plain language of the statute as akin to a substantial underreporting penalty. There's no requirement within that statute that provides for intent. It just provides, as I recall it and read it, it just provides for primarily a monetary limit, and then provides exceptions for natural disasters, those types of occurrences, as to why that underreporting would have occurred. I just wanted to put that on the record so it's understood the taxpayer's position with regards to that 40% penalty and the state's position that it would extend the statute of limitations for assessment. I also wanted to address the state said following the 2010 examination of this taxpayer that there would be no misunderstanding of their reporting requirements, their withholding requirements, those types of issues. I think the record from today's meeting shows just how easy it is for there to be a misunderstanding about sales and use tax issues. It's quite clear, even with regards to the mandatory tips, the taxpayer still had substantial questions even following that 2010 examination. It just appears to me to be a false reading of the facts to say, as of that date in 2010, there should be no misunderstanding as to their requirements under the law. Additionally, I'd like to address that in reference to the audit manual that CDTFA is relying on, it does appear to be so vague as to, on some of these issues, lack any value in what it allows a finding of fraud to be based on. Almost any action that results in an underreporting could be through the use of circumstantial evidence interpreted to be fraud or intent or intention to evade. that's especially true in cases as this one, where the circumstantial evidence in every case is interpreted to the detriment of the taxpayer. Here, there's no proof of enrichment by the taxpayer, as we discussed. Mr. Lee, as manager, was paid a quite reasonable salary. There's no evidence that the owners of this corporation unjustly enriched themselves, that they lived a lifestyle that we generally will see in cases of fraud, where trust fund taxes are taken by an owner or a manager. Based on the facts on record, the burden of the state to provide clear and convincing evidence of intent to evade or intent to commit fraud hasn't been substantiated. Thank you.
Thank you. I'm sorry. I just had one additional question that occurred. I'm wondering if there's any indication in the record, I guess, for either party on whether or not the owners had prior business experience operating a seller's permit.
They did, and I believe that's explained in our fraud memo. That is, let me see what page that it would be. Page 24 of the joint exhibits, and it would be item number 2. So it says the president of ISIF Madfish Inc. is Mr. Moojun Lee. Mr. Lee is experienced in running the business for over 8 years and as a fast food business, and Mr. Lee is president of another business, Fremont Gateway, as a restaurant, and Mr. Lee as secretary. So he was involved in other businesses during the time of the reporting for these periods.
Okay, since you just had your closing, I guess I should offer you a brief opportunity to, if you'd like to address that.
Yeah, absolutely. Thank you, Your Honor. I would just like to present that I believe the record would show that those other businesses also ran into sales and use tax problems. I don't know that necessarily paints Mr. Lee in the best light, but the reason I raise that issue is to just show that he wasn't a sophisticated businessman, running these businesses until one day he decided, I'm going to run a Japanese restaurant into the ground and steal all the sales and use tax from the state. The record even, let me frame it this way. I just believe it shouldn't cut both ways to Mr. Lee's detriment. He did have business experience. We concede that point. That business experience also resulted in sales and use tax liability, which I believe has been assessed against him personally in at least one case. These were pretty much concurrent periods. So the same issues we're dealing with this taxpayer, ISIF Madfish, Mr. Lee had also concurrently ran into them with the other businesses he operated.
Okay. Would CDTFAA like to do their closing arguments?
We would. The department believes that we've established by clear and convincing evidence of an intent of the taxpayer to underreport their sales and use tax. The difference between the amount of sales that were reported to the federal government on their income tax returns was substantially different than the amount that was reported on the sales and use tax returns. For 2011, there was a difference of $471,000, and for 2012, there was a difference of $1,129,000. So there was clearly evidence that the taxpayer had that they had the ability to report the proper amount of tax, or at least an amount of tax that was substantially higher than the amount that they reported. The credit card receipts starting at October of 2010 as compared to what was reported, the taxpayer reported just over $1 million in taxable sales during that period of time, and they had $3.6 million in credit card receipts. This is a substantial difference. A person operating a business, although they might not have business experience or accounting experience, they know about how much sales they have on any particular day. And sales for days of the week do change. More sales typically are made starting with Friday, or as the week progresses, the sales generally get larger. At the time that we conducted our scope inspection, which was in October of 2010, the taxpayer had told us that their sales were at least $2,000 a day. The amount of sales that they reported on their returns, some of them were as low as $60,000 for a 3-month period. That's only $20,000 a month. That's substantially below what they knew the sales were. And another indicator is the markup that they reported to us. For 2011, based on the sales that they reported to us, it was about a 28% markup. And for 2012, it was a negative 43%. So what that means is that they bought $100 worth of product from us, and they reported, they bought $100 to sell at their business, and they reported $57 in sales. So not only should there have been $300 and something in sales for that period on a hypothetical $100, but they only had $57, which would lead to the negative 43% markup. So they didn't even report the cost that was that they purchased to sell. As they reported, they collected the sales tax, so they knew enough to collect the sales tax. The differences remain unexplained. Even though they kept the point of sales, and there's a substantial difference with the point of sales, they cannot explain what they used to report. So even though we put them on notice, the taxpayer continued and, in fact, increased their underreporting over time instead of complying after they were put on notice. So for those reasons, the department believes that we have established clear and convincing evidence of an intent to underreport, and that our determination should be sustained, and except for the first 2 years, which we have conceded.
Okay, thank you. Mr. Njija, are you ready to conclude? Mr. Robinson? Yes. Okay, thank you, everyone. So this case is now adjourned. The record, however, will be held open until Thursday, March 28th, 2019, for either party to submit additional briefing on whether the 40% penalty is an evasion penalty, if they so desire to submit briefing, and additionally the CDTFA to submit additional information regarding the amount of its concession in this appeal. Thank you, everyone, for coming in today. The judges will meet and decide your case after the record is closed, and you should receive a decision within 100 days after March 28th, 2019. Thank you. The hearing for ISIF Matchfist is now adjourned, and we'll have a short recess before we proceed to the second item for today.
Thank you.
for a second? Yeah, it makes me feel better too to have a plug in.
Could you please call the next case?
Our next case is the appeal of Gholamreza Shafazand, case number 180-11844.
Good morning.
Good morning and welcome. We have a few preliminary things to discuss before we begin, but I wanted to introduce myself. My name is Neil Robinson. I'll be the lead judge for conducting today's hearing. We have Grant Thompson and Andrew Cui as the other two panel judges. So I wanted to just have a preliminary discussion about a few evidentiary things. My understanding is that only Mr. Shafazand will be testifying today. Is that correct?
Yes, from our side.
Okay. And then we have scheduled arguments, starting with CDTFA for 20 minutes, and also Mr. Shafazand for 20 minutes, correct? And we have 15 minutes scheduled for the testimony. Since we had our conference, additional exhibits were submitted, and I gave the opportunity for CDTFA to exercise any objections that they might have. It was not done before today's hearing, and I'm going to give you an opportunity now to object to any exhibits, and maybe we can have a discussion about that if necessary.
Sure. No objection to the exhibits that were provided prior to today. I understand there's something additional that's being provided today as an exhibit, and we would object to that.
Okay. And so I think you're referring to a declaration that's dated February 24th, 2019, that was provided by taxpayers today. Is that correct?
Correct.
Okay. What is the nature of your objection?
Everyone was told prior to the hearing and at the pre-hearing conference that there was a deadline for providing exhibits. We provided our exhibits. Mr. Shafazand had an opportunity to provide his exhibits, and he did so timely, and this is something that we were not aware of. We don't even know who this person is, and I'm looking at the nature of what the declaration is. It discusses people we've never heard of. It's not anything that we could research and look into at this point, so we would object to its relevance at this hearing. Okay.
Now, if I could refresh our recollection, there was a pre-conference order that required the parties to disclose their witnesses and documentary evidence. That CDTFA complied with that order, but the taxpayer did not. Then we had the pre-hearing conference, and we discussed that, and we gave another opportunity to provide documentation and evidence on or before February 15th. Correct? Okay. The last order, however, allowed an opportunity to show good cause why you were unable to produce evidence that was submitted today before today. And so I want to give you an opportunity to explain.
Okay, and I'll let Ray answer that because this is an acquaintance of his that I had asked him to, if there was anyone else that could substantiate the fact that, and we'll get into the details in a little bit, but essentially that he did not have that much to do with the business operations. It was just recently that he was able to get this, and so can you explain, Ray, why?
Yes. Good morning. Rachel Alexine, I've known her since 2004 as a friend, and I asked her to come in and watch over the business while I was gone. I reached out to her after our conference, and she had a death in her family. And the day that she came back, she was able to produce this and give it to me. That's why it's didn't fall within the timely manner, Your Honor. And she's available by phone to ask any questions if you may have.
CDTFA, do you have any response?
We object to the evidence, to the declaration.
Can I add a comment?
Sure. Yes.
The purpose, as I understand it, of this hearing is to get to the truth as best we can, given the facts. And I don't know that your decision will be based. I mean, if we present enough evidence that you agree with our side of it, this is academic, this statement. But what I would like to say is that we want to get to the right answer. If this third party is testifying that this is the case, although I respect the CDTFA's position that they haven't validated this, the people in this that Ms. Bergen has commented on will come up in the presentation. However, anyway, I just wanted to make that statement. Thank you.
Well, Mr. Cruz, this document is dated February 24th, but it was not provided until today. Is there a reason for that?
I hadn't seen it myself until today. Did you get it on the 20th? See, what is this? The 27th, isn't it? So it's 3 days ago?
I drove to South Bay, Your Honor, met up with her. She wrote the statement. She's a notary public herself, but we went to Kinko's, I believe. They notarized it, and then I drove back, and I contacted Mr. Butch Cruz, and I said I finally was able to get a statement, and I'll bring it to the hearing.
Well, if I am inclined to allow this into the record, it means that CDTFA, pursuant to our regulations, has an opportunity to have a 30-day period to ask this witness written questions. So would you be inclined to do that if I allow this into the record?
If you did that, I would make that request and then evaluate the situation and see if we need to send her a letter.
Well, upon the representation of a death and the inability to get this before today, I will allow the declaration into the record, but I will allow CDTFA an opportunity to ask questions of this person pursuant to our regulations. So this case will not be submitted today. We'll give sufficient time.
Thank you.
Okay, let's go on the record. Everything that we say today will be recorded by a stenographer. We are opening the record in the appeal of Mr. Shafazand before the Office of Tax Appeals in OTA case number 180-11844. Today is February 27th, 2019, and the time is 10:20. Today's hearing is being heard by a panel of 3 judges. My name is Neil Robinson, and I will be the lead judge for the purpose of conducting this hearing. Judge Thompson and Judge Cui are also hearing the evidence today. All 3 judges will meet and confer after today's hearing and produce a written decision as equal participants. We've decided that we're going to hold our questions to the extent possible until the argument portion of today's case. If you have any questions during today's hearing, please do not hesitate to ask. May I please have you state your name for the record, and if you are representing someone, who you are representing?
Gholamreza Shafazand. My nickname is Ray. I'm representing myself at the taxpayer.
I'm Butch Cruz. I'm the representative for the taxpayer.
Pamela Bergen, representing the department.
Mon
Monica Silva, also with CDTFA.
And Kevin Hanks, also CDTFA.
Okay, thank you. We have documentary evidence that we have accumulated before today's hearing, and there's an evidence log. I also provided a copy to each party of all of the evidence that has been identified. And so we have CDTFA exhibits A through O. Does anybody have any objections to those being admitted into this record?
No.
Okay. Then we're going to admit CDTFA's exhibits A through O as evidence in this hearing. Appellant has just added a new document that I'm going to label Appellant's Exhibit 10. So we have Appellant's Exhibits 1 through 10. We have noted an objection that CDTFA has to Exhibit 10. And aside from Exhibit 10, Exhibits 1 through 9, are there any objections?
No objections.
Okay. Then Exhibits 1 through 9 are admitted into this record. As to Exhibit 10, over CDTFA's objection, I am admitting Exhibit 10 into the hearing record with the understanding that CDTFA will have an opportunity to follow up with the person making this declaration. The opportunity to respond to the declaration is pursuant to the Office of Tax Appeal regulations. We have two issues that we're going to hear today: whether appellant was responsible for the sales and use tax compliance of Renzo, and whether appellant willfully failed to pay the sales and use tax of Renzo during the audit periods. Do those accurately represent the issues that we are going to hear today?
Yes.
Yes.
Okay. Mr. Cruz, you may call your first witness.
Okay, what I'd like to do, with your permission, is just to kind of give my presentation, and the witness is going to be the taxpayer. He will augment wherever you have any questions. One thing I would like to clarify is, Ms. Bergen has accepted the exhibits 1 through 9 previously admitted. Two of those exhibits have to do with a passport information and a signature stamp. And I couldn't email those, so I brought them. And I think I mentioned that in my opening argument on the telephone that I would, and they're here, and I don't know if they want to examine them. One of the exhibits has just copies of relevant pages of the
passport.
Passport, yes, sir. And I think a copy of the signature stamp that's created from this, which is a very important part of the case. And so I don't know if anybody wants to examine, touch, feel, review, but I wanted to make that clear.
Preliminarily, let's have CDTFA examine those exhibits. I know that the passport, we have pages of the passport. You're bringing the passport to authenticate those copies of the documents that are in evidence. CDTFA, do you have any objection to?
We don't.
Okay. Now, the signature stamp is a new exhibit today. We were unaware that that was coming. CDTFA, do you have any objection to the use of the signature stamp as a demonstrative exhibit?
Again, we were not aware that this was an exhibit that was going to come forward today, but I don't really have an objection to it, no.
Okay. Now, the next question is, how are we going to put the signature stamp into our record? Can we perhaps agree that the appellant brought the signature stamp to our hearing today, that there's no objection, and that the testimony will reflect what that signature stamp is so that we don't have to physically take it into our record?
Sure, that's fine.
Another alternative is that we can have it stamped on a piece of paper and bring that piece of paper into the record. Would that be acceptable?
It is with me, yeah.
Your Honor, may I?
That's fine. Yeah, that's fine with
One
us.
moment.
We have no objection to that. That's fine.
Okay, yeah, why don't we do that? Can we do that now before we continue?
Sure.
A blank piece of paper, do we?
I have no objection if they want to keep the stamp for 30, 60, 90 days.
I understand. Thank you, Mr. Shafazand.
You can do it here. I doubt it. There you go.
Okay.
Dana took that. She wants to make copies.
Sure. Dana, could you make copies of this for us? I'm going to mark this signature stamp as Appellant's Exhibit 11. Okay, while we are waiting to receive that, I understand, Mr. Cruz, that Mr. Shafazand is going to supplement your presentation. I would like to swear in Mr. Shafazand. So, Mr. Shafazand, could you please stand? Do you solemnly swear or affirm that the testimony you will give today will be the truth and nothing but the truth?
I do, Your Honor.
Okay, thank you. Okay, Mr. Cruz, please continue.
Okay, so my contention is that Mr. Shafazand had a remote relationship regarding the filing of the sales tax returns or the paying of the bills. And I won't bore anybody with Section 6829 because I'm sure you're all familiar with it, but it highlights the fact that he's knowingly and willfully withheld the payment of the taxes, responsibility, that type of thing. You have the history that I admitted in Exhibit 1, so I don't know that it's necessary for me to go through the whole thing, but maybe I should. The seller's permit was obtained in July 2004. I believe that's part of the CDTFA's exhibit. It has the taxpayer's signature on it. The business started with Mr. Shafazand being a principal investor. DBA changed to Sabor, remodeled to open in June 20th. That's important because the city of San Jose did not want the nightclub to reopen. And so they came in on the opening night after a lot of advertising and everything for the opening and did not allow them to open. They prevented them from opening. The taxpayer subsequently obtained a restraining order allowing it to open. That caused a lot of negative publicity, hence not very good business operations. So the business did not do too well. They had to reinvest in getting it up to speed. And then in August of 2009, the taxpayer was involved in a very serious automobile accident. Exhibit 3 is documentation that supports that he was in the hospital and the severity. Then he had back surgery in September of 2009. Exhibit 4 addresses that. Here's where the three strangers, if you will, previously alluded to, come into the picture. January 2010, Isaac, Carlos, and Pierce managed the business. Mr. Shafazand had an ownership interest but was not active in the business operations. Mr. Shafazand pursued other business opportunities trying to find them. He traveled, yes. Oh, okay, excuse me. Mr. Shafazand corrects me that Carlos and Isaac came in and What year was it? You need to speak in here.
They came in 2008 after we were able to reopen. They lost their club, which was stated right behind my club. They lost their lease, and then they joined me as far as operators.
Who is they?
Carlos Carmona, Isaac Barrera, and Pierce Caldani. They were the operators of Taste Ultra Lounge nightclub in San Pedro Square, San Jose, which I believe Mr. Tom McHenry, the previous mayor of San Jose, owned that building and was planning to get a grant from a city to redevelop the whole area, which mine was part of it as well. So they somehow they voided their lease and they lost their club. I closed Cucini because in 2004 I opened it. In 2007 I became ill, so I left seeking medical attention. When I came back in January of 2008, I noticed that the business was tremendously low and it was really bad. So I decided to close it and reopen it with a different name and hopefully gather more business, because downtown was really dead and everybody was waiting for the downtown revitalization. The only nights that was busy was when the Sharks played. So when I closed on April of 2008, they lost their lease at the very end of April 2008. So they called me and they said if they could move their operation to mine. And I used to see that they had a very huge crowd and there were a lot of business. And I'm like, that's great, because I was losing a lot of money. So when we reopened, one of the reasons city shut me down on the grand opening night was because those guys were involved. And Mr. McHenry had apparently spent a lot of money trying to get him out. So they didn't want him back in downtown. So I had to go and get a restraining order from the city and allowing me to reopen. And that's when they started. You can go ahead.
Okay, and along those same lines, Exhibit 5, if you want to just take a look at that, it's a copy of an email that is from Isaac, one of those individuals that he referenced, to Nadine, whom I'm assuming, and maybe Mr. Shafazand can clarify her role, but I'm assuming she was like a bookkeeper or something.
She was a bookkeeper.
Okay, so let me read the email. Nadine, please print out a list of uncleared check for operating account and payroll account. I also need a list of unpaid bills to date. Chris wrote a check out to Southern yesterday for $3,900. Southern is a supplier of alcohol. Chris, please provide Nadine with payment receipt and check number. Thank you, Isaac Barrera. So there, to me, that kind of supports our position that this fella was the one calling the shots as far as paying the checks and that kind of thing. So moving along, then Ray went to Thailand to rehab, came back for his back, returns from rehab in July 2010, August 2010, in support of the position that he was really an investor. He borrowed $120,000 using the Sabre equity to purchase a new business called the Myth Lounge. In April 2011, they had to do a lot of construction work to get it up to speed. So it was about a year, well, I guess it was about 9 months later, they opened up the Myth Lounge, a different business and at a different location. I also have in Exhibit 7 a copy of a news article from the town of Campbell, California, that highlights Ray's name in there as being a principal in trying to invest in a business called Gaslighter Theater. And so, again, that's Exhibit 7. Again, demonstrating that, his role was not one of actively managing the business, but more so of seeking opportunities. In January, Ray was involved in a personal issue, was arrested, and he was encouraged by his friends and family to stay away from the bar business, if you will. The nightclub business is kind of what it was. And so he did. So he actually moved to Thailand, was there for about a year. He left in April, I guess, 2012, came back in January of 2013 to address the legal issues. And then in June of 2014, he sold the balance of his investment into the business that we're addressing here to ISIF, or excuse me, it's the other business, the Myth one that he just purchased. December, his house was foreclosed on. He had to leave immediately, and it was a sudden eviction, to the point that all he could do is grab his personal belongings, his clothing, and that kind of thing. What was left behind and apparently destroyed were records of the business that he had run, and so consequently there was nothing to address when the auditor came and did the audit, and as we previously discussed in the preliminary hearing, that we're not going to address the results of the audit, but rather 6829 as it applies to Mr. Shafazand. In March of 2017, his wife passed away, and so he was further removed from doing things. I go on to state that Ray was an investor in the business and researched other business opportunities. He was not active in the day-to-day operations. His signature stamp, which we all have a copy of, was used on checks and other legal documents without his review to facilitate ongoing business needs. He was rarely available. He did not control nor supervise the filing or payment of the sales taxes. Throughout the audit period, his activity was very limited due to his health, the accident, and legal issues. He could not oversee the business operations, and he should not be held personally liable for the underpayment of the sales tax. Now I'm going to turn to Ray to see if he has anything to add to that before we close our...
Now, you realize that you are his representative and you're making arguments, you're not presenting evidence.
Correct. Yes,
so
yes.
Mr. Shafazand is here to present evidence.
Okay.
All right.
Ray, do you have anything to say, augment anything?
Well, as Mr. Cruz mentioned, my illness, and it took a toll on me, and so I was literally away from the business. I had these guys running it, and I felt like as long as the rent is paid and the taxes are paid and everything is paid, it's okay for now. All the employees are being paid, and not knowing that, all this stuff was going behind my back. The restaurant, bar, nightclub is a cash business, Your Honor. It's very easy to conceal cash from anybody. Anybody can steal from anybody. Unless you're there yourself as an owner, they'll steal from you. I don't care who it is. You rarely find someone that doesn't pocket $100 or $200 cash at the end of the night and go home. I was sending emails to the bookkeeper and them on a monthly basis, and I would say, send me the month sales and send me the receipt of the rent payment and so forth. And they would provide me with numbers. I was 16,000 miles away. I was not physically present. In 2009, when I broke my back, I came back in end of first quarter of 2010, and then I couldn't physically stand or sit because of pain. So I would stay home and try to find other business opportunities, which I found meth. We took it, and then I also found the restaurant, the Gaslamp Theater in Campbell, which I spent a lot of money, close to I want to say probably 100,000 PR and all that, and then we lost the vote at the council meeting. And then 2 days later, I was set up and I got arrested. So my counsel suggested that I leave town. So I did. And my counsel was Mr. Chuck Smith out of Redwood City. And so I left, and I came back for a court hearing in January 13. And I believe in November of 2013, if I'm not mistaken, or I can't remember correctly, but I provided the dismissal. The case was dismissed, and then immediately after, I was awarded a factual innocence. And then the DA kept a copy of the case as a Brady violation, giving me an opportunity to go after the source and the police department for acting the way they did. But I didn't pursue it.
Well, Mr. Shafazand, we're running up against our 15-minute deadline,
Sure.
but I don't want to cut you off. I'm not clear about the importance of your arrest and criminal case as it relates to the issues that we have today.
Right. Your Honor, my whole point is that I was not 100% involved in the operation of Cucini's or Sabor. I had operators handling it, and I put my trust in them. They had my signature stamp. They had the login for the state online filing. And the only thing I can assume, I have even provided an email where they say that they have the cash envelope. So what I did to try to stop all this was I opened up several accounts, operating account, tax account, rent account, so everything will be deposited in a timely manner and be withdrawn out of that. So I was not there, and they were stealing. That's what I'm saying. I'm trying to say that I should not really be personally liable because I wasn't there when they were stealing.
Okay.
Let me just close with a last comment that I forgot to make, and I know that CDTFA has not had a chance to analyze the effect of the stamp, but I think you'll find that at least in most of the exhibits that I saw, a lot of the CDTFA case is prevalent or dependent on the signature stamp on the checks, and I think you'll find that it's exactly the same as the signature stamp is on the checks and on the few tax returns that were signed and some of the other documentation. You'll find that when the permit was taken out, where you need to be present, that the signature is a little different. And just like most of us, if we sign 100 times, it's not going to be exactly the same. So anyway, I'm finished.
Thank you. CDTFA, do you have any questions for Mr. Shafazand?
No questions.
And at this point, we're going to enter the argument part of this case, and CDTFA, by our agreement at the time of the pre-hearing conference, is going to go first. I want to note that CDTFA is not under oath. This is argument, not testimony, and that explains why they are not under oath. Okay? Ms. Bergen, please continue.
Thank you. As you're aware, 4 elements must be met for personal liability to attach under Section 6829 of the Revenue and Taxation Code. The first is the corporation must have been terminated. The second, the corporation must have collected sales tax reimbursement. Third, the person must have been responsible for the payment of sales and use tax. And fourth, the person's failure to pay must have been willful. In this case, there's no dispute as to the first 2 elements. Both parties agree that Renzo's Bar and Grill ceased business operations on August 31st, 2012, and that it collected sales tax reimbursement. As to the third element, whether appellant was a person responsible for the corporation's payment of sales and use tax, appellant argues that he had a very limited role in the filing of the corporation's sales and use tax matters and that he was simply an investor in the business. Responsible person means any person having control or supervision of, or who was charged with the responsibility for the filing of returns or the payment of tax, or who had a duty to act for the corporation in complying with the provisions of the sales and use tax law when taxes became due. In this case, there is ample evidence that appellant was the person responsible for handling Renzo's sales and use tax matters throughout the liability period. For example, appellant signed Renzo's seller's permit application listing himself as president, secretary, and treasurer. That's our Exhibit A. On Renzo's statement of information filed with the Secretary of State's office, appellant is listed as Renzo's CFO, CEO, secretary, and director, and his name is typed at the bottom with the person who completed the form, and his title is listed as president. That's our Exhibit B. Appellant signed and executed Renzo's articles of incorporation filed with the Secretary of State. That's Exhibit C. Appellant signed Renzo's sales and use tax returns for the first, second, and fourth quarters of 2006. That's Exhibit D. He submitted Renzo's electronic sales and use tax returns for the fourth quarter of 2008 through the third quarter of 2012 as president. That's Exhibit E. And he filed Renzo's electronic prepayment forms for all of 2010, August 2011, February 2012, and May 2012. That's our Exhibit F. On a responsible person questionnaire dated April 8, 2013, appellant listed himself as the only person who had control, supervision, responsibility, or a duty to act for the corporation in sales and use tax matters at the time the business terminated. That's our Exhibit G. Finally, Exhibit H includes several other business documents that are signed by appellant as president. Based on our evidence, appellant was responsible for handling Renzo's sales and use tax matters, and the evidence provided by appellant doesn't change the fact that he was the sole corporate officer of the business and that he listed himself as the only person who was responsible for the corporation's sales and use tax matters on the responsible person questionnaire. As to the fourth element, whether appellant's failure to pay was willful, appellant argues that the department hasn't really established that he was willful because it's unfair to hold him personally liable. Failure to pay is willful if the person had knowledge that the taxes were not being paid and the person had the authority and the ability to pay the taxes but failed to do so. As to knowledge, Exhibits D, E, F, and I show that appellant knew that Renzo's taxes were not being paid. As the president of Renzo's, he submitted its sales and use tax returns and prepayments, and he discussed the first audit's liabilities with the department staff. You'll see that in Exhibit I. Because appellant was the only person responsible for Renzo's sales and use tax matters, as he acknowledged himself on the responsible person questionnaire in Exhibit G, and because the liability is established using Renzo's own records, appellant knew that Renzo was underreporting its taxable sales on its sales and use tax returns at the time those returns were being filed. As to authority to pay the taxes, Exhibit H shows that throughout the liability period, appellant signed power of attorney forms, multiple waivers, and installment payment plans on behalf of Renzo's. And our internal ACMS notes show that on September 4th, 2014, appellant told staff that although there was one other person on Renzo's bank accounts, that she needed his approval to sign any checks, and that he was the only person on Renzo's bank accounts who had the authority to issue checks. Finally, as to ability to pay the taxes, Renzo's had funds available to pay, but instead used those funds to pay other creditors. Exhibit K shows that Renzo's paid over $1.9 million in wages throughout the liability period. Exhibit L shows that Renzo's paid over $1 million in lease payments throughout the liability period. Exhibits M and N show payments to vendors and PG&E during the liability period. And Exhibit O shows that for 2008, 2009, and 2011 combined, Renzo's income tax returns reported cost of goods sold of over $1.5 million. All of this evidence shows that there were available funds to pay Renzo's tax liability, but the funds were paid to other creditors instead. Appellant hasn't provided any documentary evidence to show otherwise. As to the signature stamp, the evidence that we provided today, for the most part, requires an actual signature that's sent in or done in person. So the stamp, in my opinion, is not relevant. And if the stamp was actually used, again, the only person who was responsible for this corporation was appellant. As the sole corporate officer, He doesn't get to negate his liability or his responsibility or his duties of what goes on in his corporation simply because he wasn't physically there every day or because he failed to review all the documents that were being signed or a stamp was being used with his signature. It was his responsibility to review anything that was being signed. And I don't believe that appellant has stated that anyone wrongfully used his stamp or that it was done without his permission. I don't believe there was any sort of a fraudulent intent that he's claiming. I don't think there were police reports filed that anyone stole his identity. Based on all this evidence provided here today, the department has clearly met its burden of proving all elements for imposing personal liability to appellant. For these reasons, we request that this appeal be denied. Thank you.
Thank you, Ms. Bergen. Mr. Cruz?
Yes.
May I answer, Your Honor, for a second?
Well, Mr. Cruz.
Yeah, okay, go ahead.
You're not going to, I don't think you know this. Your Honor, when I was evicted from my house, I had boxes of checks where I had written from my own line of credit, from my home line of credit, to the business to support the business. I'm sure there's not enough time to appeal it, to subpoena it, but the banks are there and the checks are written and we can get a copy of it. But it's not that the business was making money. I was pumping money into the business. I'm sorry, go ahead.
That's okay. Yeah, I just wanted to make a few statements. Appreciate the CDTFA presentation and thoroughness. She mentioned a number of times Exhibit H, and I wish you would just take a second and take a look at page 2 of Exhibit H, and you'll see a signature there, okay, that is, I believe, the taxpayer's handwritten signature. Then if you'll take a look at the signature stamp, you can see a substantial difference in the two signatures, that it isn't the same thing. Ms. Bergen said that tax returns, sales tax returns were filed with his signature. I think you'll find that all of those match the stamp, okay? And so what I'm saying is that he didn't physically look at the return, sanction the return, sign it. Same with those checks. They have that same signature stamp on it. She also mentioned another exhibit, I don't remember, D maybe, whereby the electronic returns, as the state progressed into a paperless society, we have this electronic returns. It states on there his name. It doesn't say it's him. I've used codes for taxpayers that I've represented where I could go into their account on the state website and file a request for penalty relief or just about anything, and it's not them, it's me. So I don't think that proves a whole lot. So, and then the comment about willful and the person. I think of Microsoft. The president of Microsoft was a guy named Bill Gates. Okay, so he's the president. Would Bill Gates be personally liable if Microsoft was, guilty of not paying all their taxes? I don't think so. It's just not realistic. And so, anyway, as far as rebuttal to anything she said, I think we've shown that he wasn't there, he didn't have an active role, and he shouldn't be held personally liable.
Okay, thank you. Anything else, CDTFA?
No, I think we presented our case.
I'm sorry, I didn't catch it.
We've concluded presenting our case.
Okay, thank you. Is there anything else that we need to address before we close the record?
I have a question.
I have a few questions of Mr. Shafazand. I'm concerned that I'm not completely understanding some components of your testimony, and I'm a little confused. At one point, you testified today that you were out of the country, right? But you were in communication with your bookkeeper.
Via email.
Yes, and this is the bookkeeper that kept the books for the business.
Correct.
Okay. What was the purpose of keeping in touch with the bookkeeper?
The reason was I was injecting funds into the business, as I just mentioned, and I was wondering, and I was asking the bookkeeper, why do you guys need $25,000? Why do you guys need $40,000? So they would send me the monthly sales record where it was so much, and then the payroll was so much, and then the sales tax was so much, and the rent was coming due. So I would, via electronically, wire money into the business in order to keep the business afloat.
And who exactly did you authorize to use your signature stamp on checks?
My signature stamp was in the office. My wife, Moral, who passed away, she was also on the signature card that I provided from the Bank of America, where it states who are authorized signers. She asked me to create a signature stamp and leave it in the office because she was literally attending to my medical condition. And the bookkeeper, Nadine, and then Renee Smock and all those people were not authorized signer. So they would stamp the check and send it out. And then I found out later on that the club manager, when they would deliver the liquor, they would write the check and stamp my signature and give it out. But those were supposed to be charged to the account and paid at the end of the month, where we can look at the ledger versus the inventory and all that. None of that was happening.
Did anyone ever use your signature stamp without your authorization?
Oh, absolutely. Yes, Your Honor.
Can you tell me during what time period?
Mainly through 2008 till then the closing of 2012.
In your appeal, there was a letter attached from Mr. Shafazand indicating that in 2008 you were undergoing chemical therapy.
Yes.
And then today you're talking only about your back condition. And so
I'm still going through the therapy, Your Honor.
Okay, well, what exactly is chemical therapy?
So in 2007, I was diagnosed by polycythemia. It's a word I can rarely pronounce it myself. It's a condition that attacks your bone marrow and produces too much red blood cells. So it causes fainting, it causes blood pressure. So it deprives your blood from getting enough oxygen. So I was getting infusion every 8 weeks. Then they increased it to every 6 weeks. Then when I went to Thailand, the hospital, Bangkok Hospital, was in communication with my oncologist here. They showed progress of remission, so they reduced it. And then when I came back, about a year later, it got increased. And so they increased the infusion from 8 weeks to now 6 weeks. So right now, my oncologist is Dr. Checky, right here in Berkeley at Sutter Hospital. And I get infusion every 6 weeks.
After your back surgery, how long were you recovering?
The back surgery, after the surgery, it took me, with the physical therapy and 3 pain management injection, close to, I want to say, probably 9 to 10 months. I was able to physically function. But as of right now, even up to date, I cannot sit still for more than like 20 minutes unless I move around and, push my back or have a back support.
Okay. Judge Cui, do you have any questions?
Yes, I do. So I'm just would like some clarification on the timeline. I believe you had indicated that the auto accident was in August of 2009. Is that correct?
Yes, Your Honor.
And was that in the United States or abroad?
It was right here in the United States. It was actually on my resident.
Okay, so were you actively involved in the corporation before the auto accident? Is that your testimony? And then afterwards, that's when you left?
I was not quite actively. I was seeking other opportunities, but the gentlemen, Carlos, Isaac, and Pierce were running the operation.
Okay, so I believe a portion of the liability for which you're being held personally liable for is part of an audit liability from, it looks like, July 1st, 2005 until August 31st of 2012, and that was based on a determination issued to the corporation on February 27th, 2009. Were you aware of this liability before the closeout, or were you involved in handling this liability?
I'm sorry, what was the liability period again?
Oh, so I understand that there had been an audit of the corporation from 2005 to, was it 2005 to 2000 and, or it's starting in 2005, I'm not sure of the closeout date.
My understanding, Your Honor, was that the first audit, 2005, we concluded it, and then I made a payment plan with the Board of Equalization.
Okay, so you were involved then in handling the payment?
Well, I came aware of it because they sent a audit form, and whenever anything legal was happening, they would call me to go and battle with it. So, yes, I did go back in, and I'm like, okay, what's going on? And I met with the auditor. The auditor came actually to the business and concluded that we had like zero sales, almost like nobody there. So we made a payment plan, and I think that was concluded.
Okay, and I'm also curious about, it looks like CDTFA Exhibit J, and it looks like it's a record of a phone conversation that CDTFA, I guess at that point it would have been the BOE, had with you. And in this note, it indicates that you informed, if I'm reading this correctly, that you informed CDTFA that this Moral Rahini, the restaurant manager, was required to get approval from you prior to issuing checks. Is that correct, that the operations manager was required to run any checks for you?
Yes, that was the deal, Your Honor. They were supposed to call me or text me or email me the ledger of the checks that was going to be issued, and I was to approve them. But being sick and day-to-day operation, they would go ahead and start signing checks and then send me a report at the end that these are the checks went out. Or I would look it up online and see what checks have gone through.
Okay, and I believe you had also mentioned that some employees might have taken funds from the business. Is that correct?
As I said, it is not uncommon in a nightlife business that bartenders or bar managers or the floor managers, they take cash. First of all, when you're entering, the cover charge is non-taxable, so it's collected. So they can easily tap into that. Secondly is nightlife, it's 50-50 credit, 50% cash. So the bartenders, they can easily take away cash and put it in their tip jar and take it home. So does the bar manager at the end of the night counting can easily count you a different number what actually was sold.
Okay, did you ever terminate anyone or file a police report based on having funds handled in such a manner?
No, Your Honor, but I did file a report twice that one of our employees stole liquor from the business
Okay.
twice.
I believe those. Thank you.
He was also claiming to our insurance as well, but I don't remember if he ever got paid from insurance or not. But there is a police report on that.
Okay, thank you.
Judge Thompson?
First, I'd like to check and see we've gotten some additional testimony and see if CDTFA has any comments or questions with regard to that testimony.
Well, as to any sort of police report or anything like that that was filed, we have no evidence of that whatsoever. We've heard of that just today. And again, my response would be, as the sole corporate officer, you can't just relinquish your duties. And if you do that, you have to actually establish that you've done that, and you have to show that you're no longer the president, you're no longer responsible. And we haven't seen anything today or prior to today that establishes that at all.
Secondly, just in the context of understanding and thinking about knowledge and potential responsibility, it would be helpful to me if each party could give me just an overview. I think some of this is in the record, but just an overview of the scale of the underpayments. Were these 10%, a small shortfall from the sales tax that were due, or were these a large shortfall in the perspective of the parties? Appellant, if you'd like to go first.
Me? Oh, yes.
You looked like you were
I'm
ready.
not sure I understood your question. I think you were asking the amount of the liability that the state came up with for the audit period in which they're trying to hold him personally liable.
Right. So let's say, just to make, if the liability was $1, were the payments 5 cents short, or were they 80 cents short?
So compared to the reported, the percentage that it was off?
The error rate.
The error rate.
Yeah, and I'm sure that she can answer that.
Yeah.
Yeah, and there's different ways you could cut it and tackle it. What I'm looking for is just a sense of the scale. I'm trying to understand, were these a relatively small scale that might be easily overlooked, or were these a larger scale that might be more difficult to overlook?
I think I understand, but let me just repeat what, just for clarification, is that you're trying to get a feel for the, if it's a large amount, then perhaps you could assume that he should have been aware of it. If it's a little bit, then that could slip by, any account. I would say the tax is probably substantial. His ability to know how much it was underreported is not obvious. What he's referred to a number of times is the bartender or the person taking the money at the door, perhaps confiscating some of the cash. That I would assume is minimal. Okay, so he mentioned $100 a night, and they do substantially more than that. So that would go unnoticed. But to the tax liability, this was a big nightclub, and it did a lot of volume. And so as far as the percentage of what the audit came up with and what was reported, that kind of thing, he didn't have a handle day to day on what to expect, and so that when if it was less than that, then he'd go, hey, wait a minute, we're supposed to be getting 10,000 a night, and it was 2,000 or 4,000. If that's addressing your question, I'm not sure.
I think so. So I think you said it was substantial, but he wouldn't have knowledge, and is your position. And when you say substantial, do you mean just in terms of absolute dollars, which I can see in the record, or both absolute and relative to the business's sales?
I would say absolute. I'm anxious I don't have the audit in front of me, but I'm sure that CDTFA has the numbers at their fingertips.
Thank you.
As to the deficiency in that audit, the second audit, the deficiency measure was $2,753,000, and the error rate was over 200%. The taxpayer reported a little over $1 million in sales, but the deficiency measure was determined to be over $2 million in a deficiency. And we removed the audit from our exhibits because they had agreed to not contest the audit. Mm-hmm. And so if this is something that you're interested in, we would request that we be able to put those audit working papers back in as exhibits.
Mm-hmm. Does appellant, do you contest the error rate so stated?
I do, but I don't have any documentation to show that it is wrong. I believe that testimony has shown, or at least he's stated, that the records aren't available. They were, confiscated when his house went away. But I don't have any proof of that, or I would have.
I'm going to ask whether you're contesting. I'm not talking about contesting the underlying liability, which I understand is not an issue. I'm just asking whether you contest the error rate stated by her in terms of answering my question about the scale and scope of the underpayment.
I don't contest that that's what the auditor came up with.
All right, thank you. Nothing further.
I did have a question for CDTFA, since there was the potential concern that money was being taken by employees, and I'm wondering, in reviewing the audit, do we know if the underlying audit, if that was something that would have been based on the taxpayers' records, or if that was basically conducted in a manner or done in a manner that would have picked up these types of transactions where he's referring to sales being made, but the money was actually not ever going into the cash register?
The audits were based on the taxpayers' records.
Okay.
May I add something before we close?
Okay.
So in, I believe, June of 2011, we opened up Myth, which was 2 blocks away, Myth Tavern and Lounge at 152 Post Street. At that time, Myth didn't have any credit, so they would purchase liquor and all the goods on Renzo Bar and Grill's account and then sell it over at Myth. Myth was supposed to, Myth was 152 Post LLC, to be exact. Myth was supposed to pay back Sabor or Renzo's for products that being purchased. But the auditors, they took that as the products that Renzo Bar and Grill Inc. purchased and sold and didn't pay tax on it.
Okay, thank you.
CDTFA, do you have anything further?
No, I just want to confirm if we're not stipulating to the audit anymore as far as the taxpayer is concerned, I'd like to be able to introduce those 2 audits into evidence if...
I believe I heard Mr. Cruz say that there was no documentation, both here today and at the time of the conference. Okay. And so, Mr. Cruz, is it true that we are not contesting the audit?
Yes, sir.
Okay.
Okay, thank you. I just want to make sure.
Sure. Okay. If there's nothing further, then I would like to conclude today's hearing. CDTFA has 30 days from today's date until March 27th, 2019, to contact the person who signed the declaration that was submitted as Exhibit 10, and ask the person written questions and submit those written questions to us. The case will be, unless there is an intervening order to the contrary, submitted on March 28th, 2019. So I have to do this again. I forgot about the component where Mr. Cruz and his client have an opportunity to respond. The CDTFA will have to until March 27th, 2019, to submit their written questions and receive answers to those written questions and submit them to Mr. Cruz and CDTFA. Mr. Cruz, you will have until April 27th to submit any response to the written questions, and the matter will then be submitted on April 28th, 2019. Go ahead, Mr. Cruz. You sound like you look like you're having a question.
Yes, just so I'm clear on this, then the CDTFA will submit questions to me or to the person that signed the affidavit, swearing under, the notary. Is it?
I think the questions are submitted to it's Ms. Alexin. Is it a?
Rachel Alexin.
Yes. With a copy to you.
I see, and then that lady will respond to her, probably with a copy to me. Then I have until April 27th to raise any questions about those questions. Is that?
Yes.
What we're saying?
And answer the questions.
Yes.
This process is outlined in the regulations.
Yeah, I was getting to that.
In 30420.
Yes.
Okay.
Okay. Any further questions? Then we're going to adjourn our hearing. Thank you.
Thank you.
Okay. You're done?
I need to clear out for the next hearing. Step back for 1 second. I have to grab my thing.
is the file that we're using for numbering purposes?
We're taking a break for the court reporter, and when she gets back, we'll go ahead and start. We call the case.
Our next case is Abdul, Salam, and Zahida, Perveen. Case number 180119050.
Hi, everybody. Thank you for coming. We're now on the record in the Office of Tax Appeals oral hearing for the appeal of Abdul Salam and Zahida Perveen. I know you just read the number, but I'll read it for the record. 1801-1950. We are in Sacramento, California. The date is Wednesday, February 27th, and the time is approximately 11:25. My name is Jeff Hangija. I'm the lead administrative law judge for this hearing. My co-panelists today are Neil Robinson and Jeff Margolis. We're equal members of the panel that will be deciding this case. Taxpayers, can I get you to identify yourselves for the record?
Yeah, my name is Rohail Islam, representing Salam US Wireless.
All right. And Mr. Salam?
Abdul Salam?
Just identify yourself for the record. Oh, I'm sorry, Abdul Salam. Okay, you'll have to speak into the microphone so we can hear
Is
you.
it Abdul Salam?
Thank you. And for CDTFA, can you please identify yourselves for the record?
Scott Claremont.
Munjin Hay.
Kevin Hay.
Thank you. We had agreed at the pre-hearing conference in this matter that this appeal involves one issue, which is whether appellant has established that relief from the tax is warranted based on erroneous prior audit advice. We had also agreed during the pre-hearing conference, appellant had one exhibit, CDTFA had two exhibits, all of which had previously been provided to the parties as part of the briefing, and the parties indicated they had no objections to the evidence. Is that still the case? I believe it is. Okay. OTA, Office of Tax Appeals, we have already marked the appellant's exhibit as Exhibit 1, CDTFA's exhibits as Exhibit A and B, and we've electronically provided them to the parties, and the panel has them as well. And based on the pre-hearing conference, it's my understanding that neither party has any witnesses for today's hearing. That's still correct? Okay, so we won't swear anybody in. You'll be making arguments. It's not necessarily testimony. So it isn't testimony, it's only arguments. And as the parties agreed during our pre-hearing conference, we will begin with appellant's argument You had said it would take 15 minutes or less. CDTFA will then be allowed to ask questions if they wish, as can the judges. CDTFA will then make its presentation. They limited themselves to 10 minutes. You can ask questions, as can the panel, and then you'll have 5 minutes to rebut their presentation if you wish to. And with that, we can turn to you, Mr. Islam, and let you start with your presentation whenever you're ready.
Thank you, Your Honor. So I want to start with the second audit that we had. So according to the tax department, all the tax was paid properly. The only thing that we disagree on the rebates, that the rebates should be taxable. And as we argued that we never knew that we supposed to charge tax on the rebates. And in the first audit, even at that time, we used to get rebates. So if you on Exhibit 1, page 1, and that's the email that states that we get rebates into the BrightPoint account. And on the next page, page 2, Exhibit 1, that's just the history of the orders that was in the BrightPoint, and shows the credits and then the amounts. Then when we place orders on the BrightPoint, if we have any credit, it will apply towards the next order. And also on Exhibit 1, page 18, and that's the advertisement that Metro PCS had in 2009. So that's one of the advertising I could find. It was way back in 2009. So it shows that we still had rebates on the phone, and it was only allowed to issue rebates in stores. And in the first audit, Mr. Bryan, the tax auditor, did gain access to all the invoices from BrightPoint. So he should have noticed that there are some credits coming into the account, and he never mentioned us that we're supposed to charge tax on those rebates. So if he would have found that mistake at that time, it would have been fixed right away. But there was other mistake that we taken care of in the first audit. And then when we went into the second audit, everything, all the paperwork, all the tax was paid properly. And the other issue that we had is, if you look at Exhibit 1, page 3, this was a purchase from Best Buy. It shows that they do not charge tax on the rebates. And the phone price it shows was $17.49, and there was 2 phone purchase, and the sales tax was only $2.80. But the rebate on that phone itself was $30 instant rebate. And you can see the rebate on Exhibit 1, page 5. And you can see the phone cost price was $49, and the instant rebate was $30. So even the Best Buy was not charging tax on the rebates. So we wouldn't know that we're supposed to, as a retail, that we're supposed to charge tax on the rebate. We were just charging the same tax as the Best Buy or any other company was charging tax. And going further on the Exhibit 1, page 6, this is the order that was placed on the Metro PCS website itself. As you can see, the phone price is $19 for sale, and even Metro PCS, they do not charge tax on rebates. So when the customer come to our store, and if we charge tax on the rebate, which we didn't know at that time, wouldn't make any sense because we didn't know. And going on Exhibit 1, page 7, it shows the cost price for the dealer for the Samsung Freeform 3, that's on the number 3. So cost price was $47, and then there's a rebate shows instant rebate. And furthermore, also if you look at Exhibit 1, page 10, Walmart also does do the same thing. They do not charge tax on the rebates. Back in 2009, Metro PCS would sell at the same price to Walmart as the regular dealers, and then Walmart would get rebates too, but they would never charge tax on the rebates. So this was just a screenshot showing the chat with Walmart, and even now they do not charge tax on the rebates. And then the last one is this one is the Exhibit 1, page 19. This is the receipt from the Metro PCS corporate store. And Metro PCS itself, they do not charge tax on the rebates. And even now, they do not charge tax on the rebates. I mean, by now we did found in the second audit when Jennifer Yee told us in 2015 that we should be charging tax on the rebate, and which we fixed that issue right away. As you can see in the Exhibit 1, page 15, the daily sale starts showing that we start charging tax right away. So that was just an honest mistake that happened, but we fixed it right away. The next day when Jennifer Yee called me over the phone, and she sent me the link to show it to the customer that there is a tax that they should be responsible to pay the tax on the rebate. And we have that link available when the customer comes in. If the phone is $19 for sale, but there is a $100 rebate, the tax adds up to be like, for example, $8. The customer has a question, why there is a tax on $90 phone, there's an $8 tax. So we have the link, say, okay, we can refer them to a link. So that was just an honest mistake, so that's all.
Okay. Does that conclude your presentation?
Yes.
I'll see if we can hold our questions till the end and let CDTFA make their presentation.
Yes, thank you. So the issue in this appeal is whether appellant has established that the relief is warranted from the undisputed measure of tax of $60,486 based on prior audit advice pursuant to Revenue and Taxation Code Section 6596 and the Regulation 1705. The record shows that no relief is warranted. As you know, Section 6596 provides that if the department finds that a person's failure to make a timely return or payment was due to the person's reasonable reliance on written advice from the department, the person may be relieved of the taxes imposed and any penalty or interest added to that, unless the person seeking relief knew that such advice was erroneous. Regulation 1705 further clarifies that written advice from the department includes advice provided through a previous audit that was relied upon by either the person audited or a person with shared accounting and common ownership with the audited person, or by a legal or statutory successor to those persons. To qualify for relief based on prior audit advice, the taxpayer must establish that, first, written advice in the audit working papers reflects that the activity or transaction in question was examined in the prior audit, either in a sample review or a census review, meaning an actual review. Number two, written evidence in the audit working papers reflects that the activity or transaction in question was properly reported and no amount was due. And number three, in reasonable reliance on the department's written audit advice, the taxpayer did not charge or collect tax or tax reimbursements from the customers on the activity or transaction at issue. Here, while there was a prior audit of another taxpayer with whom appellant shared common ownership, as both the department's DNR and the Office of Tax Appeals pre-hearing conference minutes and order reflect, appellant has conceded that the prior audit failed to examine or address the audited taxpayers' receipts of cellular phone rebates. Such a concession by appellant conclusively establishes that no relief is due under Section 6596 and Regulation 1705, given that the law plainly requires reliance on actual advice on the taxability of the transaction at issue in order to qualify for relief. It's not sufficient that the auditor in the prior audit should have, could have, or must have known that the audited taxpayer had taxable rebates and or that the auditor should have educated the audited taxpayer about the issue, as appellant contends. Under law, the audit working papers must reflect in writing that the transaction was actually examined and that the taxpayer properly reported the transaction at issue with no additional tax due, neither of which was present in the audit working papers. Instead, as the audit working papers, which is in Department's Exhibit A, make it abundantly clear that the auditor did not examine any rebates in the prior audit and further did not provide any erroneous advice. First, as shown by the index to audit working papers, That's page 17 of the department's Exhibit A. The audit working papers for the prior audit contained only 2 pieces of information on cellular phone sales. There's a Schedule 12A-2-2, which is a copy of the 2009 sales summary of cellular phones, which was prepared by the audited taxpayer there, and which lists only sales of 2009 by months with total revenue and total phones sold for each month. It had only 8 lines and 3 column entries. And then we have Schedule 12C, summary of purchases from Brightpoint, 3 pages, listing only the invoice number, date, and the total amount. Those 2 pieces of documentation are in pages 27 and 29 through 31 of the department's Exhibit A. However, there's no indication within those 2 documents that the total amount of sales included rebate income. Other than these 2 documents, the auditor did not have occasion to examine any other records relating to the cellular phone side of the business, or have the benefit of the kind of documents like those in the appellant's Exhibit 1 for later years, or Metro PCS's rebate transaction reports and monthly compensation detail reports, as were provided in this audit under appeal. So there was no occasion for the auditor to examine the rebates issue in the documents provided in the prior audit. Secondly, as noted in the comment section in Schedule 12C, that's page 31 of Exhibit A, in the prior audit, all that the auditor did in reviewing the cellular phone side of the business was that he reviewed the 2 documents I just referenced above, especially the summary of cellular phone purchases, and compared the total purchases to the total taxable measure reported to note that the amount of purchases exceeds the amount of reported sales of TPP. And based on that, the auditor concluded that reported amounts were unreasonable, indicating significant underreporting, and that he could not perform any further analysis on the cellular phone sales due to the limited records. Instead, the auditor had to use a very high-level net worth analysis, as explained in Schedule 12A-1, that's page 23 of Exhibit A, to determine the audited taxable measure. Essentially, the measure of tax in the prior audit was based on the total of estimated cost of sales, rent, utility, and other operating expenses, and then estimated net income from the business operation. Given the significant unreporting due to mere estimate by the audited taxpayer, caused by the estimate, I should say, and the alternative audit method of net worth analysis, there was no way for the auditor to verify if any type of transactions was properly reported with no amount due. In sum, there's no writing in the audit working papers evidencing that the rebates were examined or that any advice was given regarding the taxability. The issue of rebates just never came up. Since the appellant concedes that tax applies to its cellular phone rebates measured in the amount of $60,486 as established on an actual basis, and the appellant has also conceded that the prior audit failed to address the audited taxpayers' receipt of cellular phone rebates, as was also reflected in the audit working papers, there's no legal basis for any adjustment to or any relief from the audited tax due, and therefore the department's action should be sustained and this appeal should be denied. And I will just briefly go over the appellant's arguments. So first, appellant argues that the audited person in the prior audit received rebates as documented in the appellant's Exhibit 1. Unfortunately, those documents were not provided to the auditor during the prior audit. As I mentioned, there were only 2 pieces of documentation. One is the sales report, several lines. The other was a summary purchase. And then as to the appellant's frustration of what should have or could have happened, unfortunately, as I stated previously, that was not the legal standard for Section 6596 relief. Instead, the law requires actual advice. And even from a factual perspective, as you can see from the prior audit working papers, when the facts were not brought to the department's attention and when the taxpayer's record records were so limited that the department had to forego the normal audit methods and opt for an alternative high-level net worth analysis method, as was in the case in the prior audit. It's very difficult for the department to identify any tax issues on which the taxpayer may need education or to give advice on anything. The only thing apparent from that prior audit was the taxpayer was reporting taxes based on estimates and did not properly keep records for sales and use tax purposes. And for that known issue, the auditor did provide the audited taxpayer proper guidance, as the appellant acknowledged through the appeal process. Furthermore, Regulation 1671.1, which provides clear guidance on rebate issue, became operative October 1st of 2007, 5 years prior to the liability period at issue. Also, the department sent out a tax information bulletin for third quarter of 2007, which went out to all registered taxpayers, and that bulletin devoted the full first page explaining the new regulation. So the taxability of rebates was well settled and well publicized before the start of the audit period at issue here. As for the practice of other cellular telephone retailers, which appellant tried to document in Exhibit 1, this appeal concerns only whether appellant owes tax on the rebates received from Metro PCS. Therefore, the practices of other cellular telephone retailers is irrelevant here. And then again, even from a factual perspective, the only information we had was the invoice, and you could not tell from the invoice whether the discounts were third-party rebates, subject to tax, or just a straight-out retailer discounts. So we cannot determine the taxability on the face of the invoice either to really come to a conclusion those retailers actually did reported rebates wrong. So basically, again, given that the appellant conceded that the auditor failed to examine the rebates and failed to provide advice to the audited taxpayer on the rebate issue in the prior audit, and given that the audit working papers also have no evidence to the contrary, no relief is warranted here under Section 6596 and Regulation 1705. Okay. Thank you.
All right. Mr. Islam, if you'd like to provide a rebuttal.
Yeah, so regarding the first audit, so we had bought the business in June 2009, and we had the first audit in about 6 months, so around 2010, beginning of 2010. I truly agree with that. We did not have enough paperwork at that time because that was our first business. But the first audit did give us a lot more information on how to keep records for this purpose. But Brian, the tax auditor, did have access to the Brightpoint invoices and access to everything that he needed from the Brightpoint. We gave him the number, and he had direct access. And as you can see in the Exhibit 1, page 1, it clearly states that there was rebates, the price protection they call it, were giving into those accounts. So if you go back into the Exhibit 1, page 29, and look at number 35, there is the amount that says $15.09. And if Brian would have noticed that which phone cost $15.09, you know, he could have asked us or called Brightpoint why there is a $15.09. And then if you go to the next page on Exhibit A, page 30, you will see a lot of more on around 46 or 47. There's also $14.98. And further down, there's $15.20, $15.29. Not a single phone cost that price. So as an auditor, he should have noticed those amounts, why there are these invoices for this amount, and could have asked us or called Brightpoint what's going on with this, and would have found out that there are credits that we are getting for the rebates into this account. And as she said, at that time, we did not have enough paperwork to provide Brian, but Brightpoint did. But in the second audit, as you can see, Jennifer Yee, the auditor, mentioned we had all the paperwork. Every single thing she requested, we gave it to her. And even in the beginning, she came up with the amount around $12,000 that we owe. But we told her, no, you came up with the wrong number. After discussing with her, it came up to $4,000 because we had all the paperwork, everything. Like I said, we paid the tax the right amount, which they agree that we did pay the right amount. The only thing we disagree on on the rebate, that we should not be liable. And this mistake should have been caught in the first audit. And we also requested from Brian, those invoices were provided to Brian and the history with the credit, and they did not attach those with this second audit. We requested them to, how come you guys don't have a record of that, even though Brian received those from the Brightpoint?
Okay. Does that conclude your presentation?
Yes.
Co-panelists, do you have questions?
I have no questions.
Mr. Margolis?
Yes, I guess I have questions for both parties. So what proof do you have that the invoices, as opposed to the summary of the Brightpoint purchases, the Brightpoint invoices were provided to the auditor? Is there any documentation that the actual invoices, as opposed to the summary, was provided?
Yes, Brian himself, he contacted Brightpoint, and he still works, I'm pretty sure, with the department. And if you need, you guys can contact him, and he's the one who received all that paperwork from Brightpoint. The Brightpoint maybe have sent him emails, but he should have all that paperwork. And in our meeting, we had a meeting with Brian, Jennifer Yee, and Tom Larson. I can give you the date. In April 29, 2015, we had a meeting at the tax office. At that meeting, we all agreed that this was an honest mistake, and even Brian himself agreed. At that time, we thought that the case was closed. Thomas himself, he said it would be untaxable, it would be on your account, but the case is closed. At that time, that's what we thought. But
I don't think anybody's saying this is anything other than an honest mistake.
yeah,
That's my understanding. That's clear here. I guess I have some questions for the department. Ms. He, when was that tax info bulletin sent out, and is there a copy of that in your exhibit?
We did not provide that as an exhibit, but it's available on the website, and that's a quarterly tax information bulletin sent out to all the registered taxpayers.
What's the date?
It just said September of 2007. I do have a copy here in my folder if there's a need for that.
I'd like to see a copy, actually. Maybe you can provide a copy.
Yeah, the other question I had is, so nobody knew, even like all the owners that I know from Metro PCS, nobody knew we're supposed to charge tax on the rebates. So
I might be able to short circuit anything regarding the tax information bulletin. Their testimony is they didn't have the business until 2009. They would not have been permitized at that time, so they wouldn't have received that bulletin.
Yeah, the prior audit person, I guess before he took over, the business was in operation, yeah, but the probably would not have reached the Mr. Salam here personally.
And I know there's a wrinkle. The prior audit should have started when they purchased the business, and instead it included the 2.5 years prior to them purchasing that business, but this specific taxpayer would not have been in existence or did not own the business, so wouldn't have had a permit, let alone an account to receive the tax information bulletin. So I don't think it's relevant, so I'm not going to let it into evidence.
Also, my understanding from reviewing the records was that the business didn't even start selling phones until mid-2009. Is that correct?
That's right. We took over we bought the business in June 2009. The old owner did not keep any good records, and the way he taught us, we took a training for 2 months with him, and the way he taught, we start keeping bookkeeping, But in the first audit, we learned a lot. But if you look at now at second audit, we have everything up to date, like all the paperwork.
Was this selling phones before you acquired it already?
Yes, it was the same business.
It was always selling phones.
Yes.
Okay. And can the department speak to whether or not it was going after the big box retailers on the rebate issue? I mean, during this time, were they really getting a pass on this, or just what was going on there?
We can't identify, which accounts that we necessarily examined during that time period, and I don't have sufficient information in front of me to know, if others had this reporting problem. There's possibility that that existed. We haven't seen it. I don't have knowledge of that happening, but I think our testimony is, regardless of whether or not that was an issue for others, that still applies to the rebate income associated with those payments.
Do you agree that the documentation is in the record suggests that the big box retailers were not collecting sales taxes on the rebates at the time?
I've seen no evidence to indicate that.
Yeah, as I mentioned briefly, the invoice alone cannot establish whether the discounts were taxable third-party rebates or straight-out retailer discounts. So, like if Best Buy put a price tag on a cell phone saying it's $400, now discount was selling it $200, and Best Buy is not getting any money from any third party on a transaction basis, then that's a straight out retailer discount, and that there's nothing wrong with excluding that from the tax base.
And it would also, it only shows that that sales tax reimbursement was not collected from customers. It doesn't necessarily show what Best Buy, for instance, was paying in tax.
Yes.
So we do get like a breakdown, as you can see in one I can show you on. If you go on Exhibit 1, page 7, so we used to get a report like this from Metro PCH, which it will show what price they're giving to which retailers, like Walmart or Best Buy. So they were getting rebates from Metro PCS. So, for example, if Walmart buys a phone at $100, then they give instant rebate to a customer, so they're selling at $49. Then Metro PCS will pay back Walmart the difference. So that's something I can, if you guys like, I can send in my email to area manager and forward that documentation to you guys. So Walmart, it was the same rules for a regular retailer or big like Walmart, Fry's. That's why they don't sell Metro PCS phones no more due to this issue.
So I don't know that we need that. I'm deciding we don't need that information because we're limited to the case in front of us, which is Salam and Perveen, the partnership. Other retailers, what they did or didn't do isn't going to give us a basis to change this measure of tax. So, though I understand everybody's agreeing this was an honest mistake, so I understand that the perception that others weren't charging it validates your position that it was an honest mistake. Everybody here agrees with that. But our inquiry is whether the prior audit shows evidence sufficient to give relief for prior audit advice under Section 6596 and Regulation 1705. So, any other questions?
No.
I had just one question. Actually, before I go, and you guys did respond to the answers to his question. I don't want to foreclose that before I start talking. So my quick question is, it is conceded, I just want to put it on the record, we have common ownership, common accounting for purposes of that prior audit to be valid to give, to enable this taxpayer to get the, to be eligible for relief under 6590. In other words, they've got standing to claim that there was prior audit advice given to a successor and common ownership in accounting. I don't think I previously had that put in the order that was agreed to, but that is agreed to as I understand it.
Yes, that's correct. The department does not dispute appellant would otherwise be eligible relief if the elements are met.
Okay. And Mr. Margolis has one more?
I have one more question. We're receiving rebates besides, you were receiving some non-taxable rebates, weren't you, during this period? Some QPay, Metro, PCS program service amounts that were also credited to your account. Is that correct? I saw something in the work papers about Metro PCS payment services income that you received.
The only rebate that I knew that we still got it just like the price protection. Metro PCS call it price protection. So if you buy a phone for $100, but in store we need to sell for $20, then the $80 difference used to go into the Bright Point at that time. Not anymore, but they will credit that $80 towards the next purchase. So if you buy another $100 phone, you only pay $20. So it will be credited. I mean, which was true in 2009. It just they did not include those invoices in this paperwork.
Okay, thank you.
I have no other questions. Judge Robinson?
No.
If neither party has any questions, that would conclude the hearing. No? Okay. So at this point, I'll close the record and conclude the hearing. I want to thank each party for coming today, especially in light of the weather. Following this hearing, my co-panelists and I will discuss the evidence and argument, and then we will issue a written opinion within 100 days of today's date. And with that, this hearing is now closed. Thank you.
Thank you.
Thank you.